What is the burden of proof for undue influence? Have you ever wondered what it takes to prove that someone was unduly influenced when making important decisions about their estate? In the world of elder law, this is a significant concern, especially when it comes to protecting vulnerable individuals. The burden of proof for undue influence primarily lies with the person challenging the validity of a will, trust, or gift. If someone believes that an elderly or impaired person was pressured into making a decision, it is their responsibility to provide evidence to support that claim. Undue influence occurs when someone applies significant pressure or control over another person, affecting their ability to make independent choices. To meet the burden of proof, the challenger must show several key elements. First, they need to demonstrate that undue influence was exerted to such an extent that it overcame the free will of the elderly or impaired individual when they executed the will, trust, power of attorney, or made a gift. Next, the challenger must prove that the person accused of undue influence benefited from the transaction in a way they would not have otherwise received. This could mean receiving a larger share of the estate than what would be expected. Additionally, the challenger should show that the decedent acted in a way that was inconsistent with their previous intentions or usual behavior. This inconsistency can indicate that the decision was not made freely but was instead the result of improper influence. The law generally assumes that elderly or impaired individuals are competent and understand their decisions. Therefore, the challenger must present credible evidence to counter this presumption of capacity and free will. This evidence might include suspicious circumstances, such as a close relationship between the decedent and the beneficiary, combined with unusual changes in the estate plan. In some cases, if the beneficiary is in a confidential relationship with the decedent and there are suspicious circumstances, the burden of proof may shift. This means the beneficiary may need to prove that there was no undue influence involved. However, this is more of an exception than a standard rule. Proving undue influence can be quite challenging. The influence must be shown to be significant enough to override the decedent's independent judgment. It is not enough to merely show that the decedent was persuaded in a normal way. Factors like the decedent's mental and physical health, the nature of their relationship with the beneficiary, and the extent of changes in the estate plan are all relevant when assessing whether undue influence occurred. In summary, the burden of proof for undue influence in elder law and estate matters rests with the person contesting the will, trust, or gift. They must provide convincing evidence that the decedent's free will was overpowered by another's improper influence, leading to an estate plan or gift that the decedent would not have made otherwise.